Good afternoon, everyone. A very warm welcome, and thank you for joining us today. It really is great to see so many people in person and not a small, blurry face on a Zoom call. So great to see so many. We are actually recording the seminar this afternoon for people to watch on catch up later. So to those who are watching it subsequently, a welcome to you too. The last time we held one of these events was back in 2018, and I think we'll all agree a lot has happened since then. In the legal field, of course, there have been a number of important cases since 2018 in the equine field, and we're going to be looking at some of those with our speakers in the course of this afternoon. Secondly, the 1st of October 2021, does anybody know why that's a significant date? It's the 50th anniversary of the Animals Act coming into force. And I think it's fair to say that 50 years have gone on and we're still none of us any the wiser. Certainly, I don't feel I am. It continues to provide challenges and to generate case law. And again, we're going to look at some of those cases this afternoon. And finally, of course, one has to mention the pandemic, which has had a huge impact on all our working lives. And when we were planning this afternoon's seminar, we said, well, should we do it in person? Should we do it online? We thought, let's do it in person. It would be really nice to get everyone together again. And I'm really delighted to see so many of you here, some of whom I certainly haven't seen for too long. So let me turn straight away to our first talk and our first speakers, Ben Bradley and Sam Cuthbert, both of Outer Temple Chambers. Sam has recently joined us. They're going to talk about the Animals Act, as well as other recent cases, a sort of legal update. Ben was called in 2007. He is a leading junior ranked for both personal injury and clinical negligence in Chambers and Partners and the Legal 500. And much of his work involves catastrophic injury, including in equine cases in which he's regularly instructed, and he's acted in claims involving some of the country's leading trainers, amongst others. He also recently appeared in the Supreme Court with James Counsel, the Casey of these chambers, in an important case involving vicarious liability, but no decision as yet, I'm sure, Ben. So, Sam was called in 2018. He has particular specialisms in personal injury and in sports law, which qualifies him uniquely to talk on this area of the law. In sports law, he acts for athletes, clubs and national governing bodies. And in his PI work, some of his work involves sporting injuries. And before coming to the bar, he worked for an international law firm in Milan, and some of his work there including advising on sports law matters. So Ben and Sam are particularly well qualified, as I say, to talk about personal injury and other sports matters, and I'm going to hand over to them now.
50 years, blimey. Older than me, the Animals Act, and it's time to strap yourselves in because we're in for yet another Animals Act rocky ride over the next 20 minutes or so with me before Sam takes you through some of the more recent cases that have been handed down. You can all work out amongst yourselves who came up with this brilliant title for the Legal Update talk, who wrote all the puns, and indeed whether there's a short wager between us on horsey-related gags in a moment. The Animals Act. Long predicted by the great, or perhaps not great, he certainly wouldn't pass an E&D interview these days, Lord Denning, who, when handing down an early judgment on the Animals Act, described it as a cumbersome section which will give rise to several difficulties. Wasn't he right about that? Then a fine cost-refining judge, Lord Justice Jackson, describes the Animals Act as like fighting through the thickets, before finally Maurice Kay described it as grotesque. And then there was a trial in the summer of last year, And there was this added commentary as the judge handed down judgment. I promise you that that is me. Indeed, that's my most recent Chambers photograph. Things haven't changed a bit, obviously. And I'm going to tell you about something that most barristers would never do. And that is to tell you all about a case that I lost at trial. It illustrates potentially new and I would say still unresolved fighting ground on Section 22A. And then, as I've mentioned, Sam will cover some cases that deal with Section 22B and give you a more general sports law update as well. So, what is this new novel argument that a certain Roger Harris may or may not have run successfully at trial in the summer of last year? Well, if you were going to be philosophical about it, the question might be this. Should we be focusing on Dobbin, or is Dobbin just a horse? Now that all might sound as clear as mud at the moment, but all will become clear in due course, as I introduce to you the wonderful concept of particularity within Section 22A. What do we mean by particularity? Well, particularity is aptly demonstrated on the facts of the case that I lost with a certain very able instructing solicitor in this room, who may or may not be on the panel later. And this case also involved some very eminent experts who may or may not be in this room, and you may well hear from later. They got off scot-free because the judge liked them. Not sure the judge liked me so much, but anyway, that aside, this is the case of Dennis and Vout Sales Limited. Simple facts that really do demonstrate how particularity can come at play and be decisive in determining issues of liability. So what happened in Dennis and Vout Sales? Pretty simple case, really. Claimant, who had worked with horses most of her life, is leading out a horse, unidentified, at the Tattersall's shows, and she has to show this horse on a runway, a sort of makeshift runway between two stable blocks. It was her case that as she led the horse out onto the runway, the horse became spooked by something, probably unidentified, shied away, crucially violently and with force, dragging her along the floor, causing her to suffer an injury to her knee. First of many times you're going to see this today, I promise. Animals Act. I won't focus on it for very long, but this in reality was a first limb Section 22A case. What do I mean by that? Well, our esteemed experts agreed that this horse, if the claimant's evidence was accepted, was likely unrestrained because it was, to use my phraseology, out of control at the time the incident took place. We weren't really feasibly arguing that this was a case where injury was likely to be severe, but it was my case that this was a kind that we were in the first limb territory where we got a horse that was unrestrained, and all the court needed to ask is whether, in the circumstances, injury was likely. And as a reminder, we will all know that when injury is likely is not on the balance of probabilities, but whether injury can be reasonably expected or is reasonably to be expected, depending on which case you read. Why is that all relevant then to the facts of this case? Well, this is what particularity is all about. The question is this: should the court consider the characteristic of spooking or shying away generally? So pausing there for a minute, if a horse just spooks or just shies away, in very general terms, is injury reasonably to be expected? Or do you look at the particular circumstances of the incident or accident? A horse, in this case, shying away with a high degree of force in the manner that it did on this occasion. Looking at that set of circumstances, is injury reasonably to be expected? And it's an important determinator of liability, because if you go down the first interpretation, which I say now the judge orbit obiter preferred, the claimant probably doesn't win. Horses spook, horses shy away every day of the week. Most people don't get injured. If the judge, on the other hand, looks at a horse, huge animal, that spooks violently, throws its handler around, well, anyone looking at that from the outside in might think, okay, injury won't happen on every occasion. But if somebody got injured, that wouldn't surprise me. Injury is reasonably to be accepted, and in those circumstances, the claimant succeeds. So, which version is right? Well, what I want to do first of all is focus on the tension in the section. This is what troubled the trial judge. So there is a tension between and this is agreed, the concept that A, B, and C within the Act need to be considered separately and distinctly. So it's a tick box exercise for a claimant. You've got to go through A, got to go through B, got to go through C. Only if you get the three strikes do you win. But there's also, on the case law, at least an introduced concept that the requirements are linked. The judges go so far as to describe them as linked requirements. Clark and Linsell, leading tort text, has a whole section on the linked requirements as between A and B. And this is what sort of scrambled the judge's mind. She conceded it wasn't an easy question. But if you're looking at things separately, then why on earth would you look at B and A together? It just doesn't make sense. And so there's the tension. And that's the tension that needs resolving. I want to take through the arguments as to why, and this is still my view for what it's worth, the linked approach is the correct approach. And there's plenty of support in the case law for that. Let's start with some concepts. Concept one, it is accepted, and the defendant conceded in the Dennis case, that you must consider the actual animal in question when considering Section 228. Now, if that's right, seems to me that it's artificial to then stop the analysis there and fail to consider what this actual animal was doing. Why have the reference to the actual animal if you don't go on to consider the circumstances of the accident? You may as well just deal with horses generally, rather than an actual animal. In Smith and Ainger, that's the case that says you've got to consider A, B, and C separately. Their lordships go so far as to say at paragraph 7 that if you're looking at the likelihood of damage, albeit, or all of it being severe, so both limbs, you have to consider the circumstances of the particular case. Now that, to me, seems as clear as day, that if you're looking at the link requirement, you look at what happened on the day in question with this particular horse. And that's not a concept that just helps claimants. On occasions, it can help defendants as well. Let's look now at the case of Clark and Bolt. Low-powered court here, just the Lord Chief Justice Phillips, who then went on to the Supreme Court, of course. And when he was looking at this case, this is a simple case about a horse doing its own thing, moving into collision with a car on the highway. He felt that the judge had rather got, he describes it as a muddle at first instance, in part because the judge had tried to deal with A, B, and C on an entirely separate analysis. And what the judge there found was, or the Lord Chief Justice found in that case, was that looking at B in facts first, that B wasn't satisfied because all this horse was really doing, or the accident really just happened because the horse was heavy. And weight alone is not a characteristic. It's a characteristic that takes place at all times and in all circumstances. It's inherent to the nature of the beast, rather than being a normal characteristic that only occurs on certain occasions. But the judge then went on to look at 228 and said, well, the other reason why this case fails is because there was no trigger in this case. There was nothing to make the horse dangerous. There was nothing to lead to the possibility of severe injury or a likely injury. And so there the link requirements meant that both A and B were not satisfied. They acted as a cross-check against one another. What Lord Chief Justice said is that you need some form of fright for the horse to react, and only then would you need to consider whether injury was likely in the circumstances. So all of that again points to needing to look at the way in which the accident occurred if you're going to consider whether injury was likely. Further reference to link requirements in the case of Bodley and Hall. This is a decision by David Pittaway, sitting as a Deputy High Court Judge, David Westcott, acting for the defendant at the time. And again, absolutely sort of express reference to considering the circumstances of the accident. I've set them out on the slide, paragraph 32, and then goes so far at paragraph 34 of that judgment to say directly the provisions of 2 to A should be read with B. So again, implies that you read them together. And then there's Jonathan's case of Lynch and Ed Walker. Was going to be Bide at one stage, but I decided to get married, so Jonathan took all the glory, but of course he won, where I'd have probably lost, as you can see from track history and form. But there, a decision from Mr. Justice Langstaff on appeal, it's not of benefit to me to read out long passages of judgment for the purpose of this talk, but worth having a look at paragraph 23, where Mr. Justice Langstaff sets out the tension from the one hand of not relying on the circumstances of the accident at all, which means you can't really define the question as to whether injury is likely to be severe, all the way to the other end, where what of course you can't have under the Act is a self-proving prophecy, i.e. the claimant was severely injured, therefore injury was likely to be severe. That can't be right. It's got to be something in the middle, but I would say again that requires looking, broadly speaking, at the circumstances of the accident, and then the court can ask, well, was this just a freak occurrence, or if you looked at it, was injury likely in the circumstances? And this paragraph of the judgment in particular, I think, sets out in stone that you look at the circumstances of the accident, because Mr. Justice Langstaff went so far, even though he found for the defendant, to apply effectively a reasonable observer test in his judgment. So he asked directly, if anyone had been standing on the side and watched what happened to Mr. Lynch, would they have thought that injury was reasonably to be expected? And he concluded, as did the trial judge, that on the facts of that case, it would not have been. But again, all pointing to looking at the circumstances of the accident. So why on earth did I lose? Well, it's the old classic, isn't it? The judge didn't like the claimant. And judges then do what judges do. So everything that followed, she conceded was obiter. She did concede it was difficult, but went on anyway to consider Section 2 as a whole, had the claimant made out her case. And she concluded that, in essence, you look at the sections in order, and that if you were to feed in questions on 2.2b to the 2.2a analysis, she said she felt that would strip 2.2a of all its meaning. And I'm afraid I just don't agree with that. Merthyr Heady deals quite carefully with how 2.2b is not stripped of all of its meaning, because you can look at, as we've dealt with already, and as Sam will illustrate on the most recent cases, you have to show a particular characteristic in particular circumstances. That's what 2.2b is all about. That is the meaning of 2.2b. But to look in broad generality as to whether injury is reasonably likely, considering a specific horse, but not looking specifically at what the horse did, in my view, is perverse. But that was her finding. The judge held that in this specific relationship, she was employed, and as such, the statutory defences were not available to the defendant. And she held that she was employed because the vout's business, or the business setup, was, in essence, the vout's and not the claimant's, asking the central question, whose business is it anyway? And so she conducted a fairly straightforward analysis. So everything up in the air on this case for both sides. And I don't think it's binding on anyone, it's all obiter. But it does illustrate in a short trial that all of these arguments are up for grabs for both parties, and they're there to run in the right cases. As Jonathan said right at the start, we're still no clearer on what the Animals Act means, but this is a new recent line of argument that is being taken and has been taken, in fairness to Roger, to good effect in the Dennis trial. The real question now to ask is to bastardise Shakespeare, to include the accident circumstances or not to include the accident circumstances. That is the ultimate question. Just some further thoughts about this. Why are we arguing about Section 228 at all on the first lib? I always thought it was pretty obvious. Maybe it's because claimants are actually pushing it too far. Another way of looking at 228 is actually that's the limb all about the propensity of the individual animal. That would be the way to square the circle. So you're really just looking at whether, if you're looking at the specific horse, whether injury was likely with this specific horse, i.e. whether it's got naughty traits, whereas 22B is really about severity of injury. So you have two separate limbs. Was it a naughty horse, where the defendant should have known better about its characteristics, or was injury likely to be severe? That's one way of looking at it and squaring the circle. Another thing to think about is whether, in fact, as a defendant, whereas at first blush, I think actually the Roger Harris approach probably helps defendants on most occasions. Doesn't always. The Clark and Bolter analysis is a good example of where, in fact, taking a sort of broader approach to Section 228 help the defendant out in the long run. So some things to think about. I'm still licking my wounds, but I've got a round table on Friday, and if it doesn't settle, I'm up for the fight again. That's everything from me. I'll hand over to Sam.
Thanks, Ben. It's this one. Great. So I'm going to provide a more general legal update for the next 20 minutes or so, as per the overview on the screen there. I'll cover a couple of the big cases from the equine world for the last few years, alongside some of the key changes for jockeys in respect of whip rules, and also an update on equine doping too. Please accept in advance my apologies for some of the puns on screen. I think I'm 2-1 up there, Ben. As we've been hearing from Ben, obviously liability under Section 2 of the Animals Act requires all three criteria to be satisfied. Ben's already gone into much depth on Section 22A. Of course, I couldn't stand here and offer a legal update without going into discussion of the Schoultz and Bull case, which of course engaged all of Section 2.2, but principally concerns Section 2.2b, which is highlighted on the screen there. And before I go any further, I should say that there are many people here who lived and breathed this case, with a number of members of OTC who were instructed on it, and I'm aware that there will be a more in-depth discussion later on. So I'll leave much of the comment to those people who are better placed to comment on it. For those of you who are unfamiliar with it, allow me to give you a brief run through the facts and some of the arguments which were put forward. So Schoultz was a matter concerning two horses which were loose at night on the A3. And I thought that the first paragraph of the judgment actually paints a very vivid picture of what happened. So I thought I'd just read that out to you because it is quite so vivid. At about 3:37 a.m. on a dark winter morning on the 16th of December 2015, two 18-year-old school friends, Sophia Schoultz and Dima Al-Hugail, were returning to Cobham after a night out in London when the red Vauxhall Sophia taxi in which they were rear seat passengers collided with a loose horse on the southbound carriageway of the A3 near Esher. The Welsh C-section mare, who was called Lowry, was killed in the collision and her body landed through the roof of the taxi, so that, broadly speaking, her head and forequarters penetrated the taxi cabin and her rear quarters were hanging outside the taxi on the offside. That's pretty harrowing. Now, Miss Schoultz had been sitting behind the driver's seat. She was retrieved by the emergency services from under the body of the then dead Lowry, and she suffered a traumatic brain injury as a result and brought a claim in personal injury accordingly. And of course, it's important to note that there were two horses on the road. The first was Lowry, the second a Dutch warm blood gelding who's called Fox. And importantly, Fox and Lowry had been kept in a herd of 24 retired horses on a fenced field by the second defendant, Mrs. Miller, who provided retirement livery services. Lowry was owned by the first defendant, Miss Ball, and she paid Mrs. Miller monthly fees to meet their animals' retirement needs. The question which was then put by Her Honour Judge Clark was as follows: the matter for my determination is a preliminary issue of liability. Is Miss Ball, the owner of Lowry, liable under Section 2.2 for Miss Schultz's injuries sustained in that collision? Miss Schultz says she is, Miss Ball says she is not. Now, I want to have a look briefly at the competing cases before the court. The claim, as you know, was brought pursuant to Section 2.2 of the Animals Act. The claimant alleged that the horses were frightened or panicked, and it was alleged that Miss Ball, as owner of Lowry, was a keeper of the horse for the purposes of the Animal Act. That much was accepted. And that Miss Ball was strictly liable to the claimant for PI caused by Lowry pursuant to Section 2.2. And the reasons are briefly set out on screen there. But on 2.2a, it was argued that where Lowry was frightened or panicked, it was reasonably to be expected that unless restrained, she would cause personal injury. Alternatively, it was put that if the horse caused PI, it was reasonable to be expected the injury would be severe. So the claimant was arguing that where a horse collides with a car as a result of being frightened or panicked and behaving unpredictably, it's reasonably to be expected that those travelling in the vehicle will suffer personal injury and or that any personal injury that they suffer will be severe. On 2.2b, the claimant relied solely on the second limb, namely that the likelihood of the damage or of its being severe was due to characteristics of Lowry which are not normally found in horses except at particular times or in particular circumstances. So it was argued here that it's within the normal range of behaviour for horses to behave unpredictably and to react with force in circumstances where they're frightened or panicked, including by running when they encounter a perceived threat. And the claimant suggested that both Lowry and Fox were frightened or panicked by adverse stimuli. Excuse me. Where they perceived as threatening, causing them to escape from the field and travel along the highway onto the A3, where Lowry collided with the vehicle. And then lastly, on 2.2c, it was suggested that the horse's characteristics, as discussed in relation to 2.2b, were known to the first defendant, with the claimant effectively alleging that the first defendant was an experienced keeper and handler of horses, and as such would have been aware of the characteristics of horses. Now, in response, the defendant says, as far as 2.2a goes, they put the claimants to proof, and they argued that the likelihood of damage or of damage being severe was due to a high-speed collision between the vehicle and an animal which was the size and weight of the horse in question. In relation to 2.2b, they denied that either Lowry or Fox were sharing any particular characteristic of dangerousness either at the time that they left the field or indeed at the time of impact. And the first defendant contended that the horses likely wandered out of the field where the fencing was down rather than responding to any adverse stimulus. And then as far as 2.2c goes, it was admitted that it was within the normal range of behaviour for horses to behave unpredictably in circumstances where frightened or panicked. And the first defendant knew that it was within that normal range of behaviour, although crucially the first defendant denied that Lowry and Fox were behaving in that way at the particular time. There was, as I'm sure many of you know, a significant amount of both lay evidence and expert evidence, collision reconstruction experts, equine behavioural experts. Some of those experts may well be in the room today. I don't intend to deep dive into that, knowing that you may be able to catch those people over a drink later if you are so interested. The key findings of fact are probably what you're more interested in. And the first thing to note here was that this was a decision made on its facts. Now, the key findings of fact, I think, could realistically be summarised as follows: that Lowry and Fox left the field over a length of 9.4 metres of downed fencing. And that 9.4 metres of fencing had come down because it was inadequately installed and fell over, rather than it having been pulled down by vandals. Lowry and Fox left the field because they wandered over the downed fence, and again, rather than them being chased or led from the field. And it was found that it was more likely than not that Lowry and Fox were not frightened or panicked when they left the field, but were relaxed. And there is another key finding of fact on screen there. So as far as the decision in light of those key findings of fact goes, the judge found that Lowry's behaviour on the night did not align with her having acted unpredictably in circumstances where she was frightened or panicked. And she found that both horses had wandered calmly out of the field and there was no evidence of Lowry or Fox being frightened or panicked on the A3. And accordingly, the judge couldn't find that the likelihood of the damage to the claimant or of its being severe was due to characteristics of Lowry which are normally found in horses except at particular times in particular circumstances. The accident was due to Lowry being a large and heavy animal who was standing on a dual carriageway where she shouldn't have been standing. And so 22B of the Animals Act could not be made out, albeit the judge did go on to say that 22A had been met, and of course 22C, as we saw earlier, was the subject of admissions. As I say, I'm going to save comment on this case for the panel to do justice later. The only point that I would underline is that it was a case very much decided on its facts. Which brings me on to another of the most recent key equine cases similarly decided on its facts. That's the case of Ford against Seymour Williams. Another claim brought pursuant to Section 2.2 of the Animals Act. This was a claim which was born out of an incident which occurred during a hunting session in 2018. The appellant's horse, or the claimant's horse to start with, reared and fell on top of her, causing her severe injuries, and then the horse subsequently died shortly after the accident. The claimant was an experienced horsewoman aged 43. She had been employed by the defendant as a groom at his yard. She brought the claim in personal injury against the keeper of the horse, i.e. her employer, on the basis that he was strictly liable for her injuries under Section 2.2. Now, at the liability trial, the court found that the rearing of the horse was what had caused the claimant's severe injuries, and that the horse had most likely reared as a result of a cardiovascular event. The judge dismissed the claim as the particular circumstances which had caused the horse to rear, i.e. the cardiovascular event, was not known to the keeper, and accordingly the keeper didn't have the required knowledge to satisfy subsection 2.2c of the Act. Now, the claimant appealed. In the Court of Appeal, the court was concerned with the interpretation of the second limb of subsection 2.2b, i.e. the animal's characteristics found at particular times or in particular circumstances, and its relationship to subsection 2.2c of the Act, i.e. knowledge or presumed knowledge on the part of the keeper. And the Court of Appeal held that subsections 2.2b and 2.2c must be considered together as a finding as to the particular times or particular circumstances during which the characteristics of the animal had arisen was necessary in order to allow the court to then assess whether the keeper had the requisite knowledge of the characteristics in order to then satisfy the 2.2c requirement. And then going on to apply this approach to the established facts in Ford, the appeal was dismissed as the cause of the horse's rearing was a cardiovascular event. The keeper had no prior knowledge of that event and had no prior knowledge that the rearing was associated with such an event. So again, what should be becoming clear here is the extent to which the two cases which I've already discussed can or cited are fact specific. And with that in mind, aware that I am rattling through these, I move on to the third, not dissimilarly decided on its facts case, Tylicki, or as I'm told, Tylicki against Gibbons. Now, as you can see on screen there, horse racing is a dangerous sport. Injuries are foreseeable in many circumstances, but this was a particularly interesting case because, as many of you know, well, many of you know better than me, incidents on the racetrack tend to happen either at the start where the horses are bunched together having exited the stalls, or indeed at the finish where the horses are putting in maximum effort to try and win. But one of the unusual features of the Tylicki case was that the incident happened mid-race. Not your typical set of facts giving rise then to a racing injury. So what happened? Well, the claimant and defendant in this case were both professional flat racing jockeys. Tylicki alleged that Gibbons's negligent riding had caused his horse to trip and fall, subsequently leaving him paraplegic. The claimant contended in this case, and the judge agreed, that the defendant had drifted left and slowed down around the bend in the middle of the racetrack at the Kempton track, which was an all-weather track, and that had brought the claimant's mount partially alongside him, next to the rail. And the judge found that as the horses entered the right-hand bend 4 furlongs into the race, that there was sufficient space for Tylicki to bring his horse beside or between Gibbons's horse and the rails, and that after this, that Tylicki's horse then moved up to the inside to a point where his horse's head was level with Gibbons's stirrup and boot. So you can almost imagine it playing out. The judge rejected Gibbons's evidence that he'd been aware of Tylicki's presence, Tylicki's presence on his inside, and found on balance that he did know Tylicki was there. And she found that Gibbons had exerted more tension in his right rein than was necessary to maintain progress around the right-hand bend and to stop his mount from drifting in a leftwards direction, that he was pulling his mount effectively across to the rail on the right, leaving Tylicki no space. And there was then an initial contact, following which the defendant made an attempt to move aside and let the claimant through, and then a second later a further contact which caused the horse to trip and other following horses to trip, with obviously life-changing consequences for the claimant. Now, this case reiterates that professional sportsmen and women are able successfully to sue their competitors for negligence whilst competing. And those of you with an interest in sports law may have read the judgment last week in the amateur rugby case of Chinuska against King. I'm not sure how to pronounce that one either, I'm afraid, but that one reiterates the point. Tylicki confirms the approach as set out by Lord Justice Judge in Caldwell in an action for damages by one participant in a sporting contest against another participant in the same game or event. The issue of negligence cannot be resolved in a vacuum. It is fact-specific. So we have it there again. And the trial judge in Tylicki was keen to explain that she wasn't setting any general precedent in finding for the claimant on the particular facts of that claim. And whilst that is true, there are nonetheless potential implications for both regulatory bodies and the insurers of all professional sports and sportsmen and women. The rules of racing prohibit cutting off of a horse, going up the inner, as it's called. And interestingly, there hadn't been any findings of dangerous riding by any jockey for 12 years prior to the Tylicki decision. Within days of that decision, a jockey called Thomas Dowson received a ban of just 13 days for interfering with a horse coming up the rail. Now, it may be a coincidence, but the reason I say this is interesting is that it may well be that the rules of racing will be enforced more rigorously as a result of these sorts of judgments, as a result of these issues being ventilated. And that must be beneficial for the safety of all competitors. And again, I'm looking forward to hearing from the panel discussion later on that point. Now, moving on, I don't think a legal update would be complete without a discussion of some of the broader regulatory changes in the equine world. There's been a significant change, which some of you may think it was a long time coming, in relation to the way in which jockeys are able to use their whips during races. Originally, there had been plans to introduce 20 new whip rules, which were due to start in early 2023, following extensive discussions. Those new rules had originally included restrictions to whip use being in the backhand position, and were designed to effectively kind of create a more considered use of the whip and ensure consistency of stewarding. Now, the backhand restriction, as I'm sure you can imagine, caused much consternation amongst the jockeys. And in January this year, the BHA following a board meeting, introduced adjustments to these rule changes, which regard the use of whip use in racing. And the key changes you can see on screen there, the rule which stated that the whip must be used only in the backhand position was removed, replaced by an amendment to the rules regarding the number of times the whip may be used in a race. Now, those rules are now that the thresholds for use are reduced to a maximum of 6 times in a flat race and 7 times in a jump race, which was down from 7 and 8 respectively previously. And there were new penalties for use above the permitted level, and again, misuse offences too. And the consternation or concerns which were raised by the jockeys included feedback that some jockeys had suffered from shoulder or collarbone injuries in the past, as is something of an occupational hazard for jockeys, and would therefore find it difficult to whip in the backhand manner. The other 19 recommendations, and I won't go through them all, which were put forward by the steering group and approved by the BHA, included a number of things, but included an introduction of a disqualification as a penalty for use of the whip 4 times or more above the permitted level, and introduced a whip referral committee too, responsible for evaluation of all rides and any necessary sanction or action born out of breach. Now, interestingly, in flat racing, the new rules are already in place. They're already in the bedding in period, so this is a timely talk for us to give. In the first week, which was last week as I understand it, 20 suspensions were given under the new rules. So it's already having a huge impact on the sport, and it's something that we all need to be aware of. And so I suppose the question is, well, why is that? Why is it interesting? For lawyers, it's going to create regulatory work, challenging decisions, enforcing bans. For insurers, there's going to be more litigation born out of the changes, with obvious associated costs for national governing bodies enforcing the rules. And beyond that, interestingly, these changes underline the delicate balance between which the sport needs to achieve between sporting performance, jockey welfare, and also animal welfare too. Now, I'm aware of the time, so I'm going to move relatively quickly through the final part of my talk, onto the final furlong, and discuss the equine doping cases. Now, those of you who are interested in this will recognise that man on screen as Jason Service. Probably the first name which springs to mind when you talk about equine doping. He's a high-profile trainer who's just pleaded guilty to doping horses in his care. His admissions relate to distribution of adulterated and misbranded drugs, SGF 1000 and clenbuterol. They were intended for administration on racehorses which were in his care and which he was training. And notably, the admissions related further to the 2020 Saudi Cup winner, Maximum Security. Perhaps fittingly, Service is now facing maximum security himself and is due to be sentenced in May 2023 alongside 30 other defendants following a fairly protracted FBI investigation involving bug devices and wire traps and all sorts of other exciting things. Beyond that, we go to Irish racing, which has seen its own anti-doping and running cases. Ronan McNally 2 weeks ago was hit with a mammoth 12-year disqualification from Irish racing. The IHRB's referrals committee found him guilty of multiple integrity breaches. He was ordered to pay €50,000 in costs and to return over €13,000 in prize money. Now, the most serious breaches that he was accused of related to him being or preventing his horses from performing to their best in order to secure lenient handicap ratings for future races, and they were then backed by his friends and associates, with obvious implications for the integrity of the races and any associated betting. And lastly then, also an Irish case, the trainer Kieran Cotter given a €20,000 fine for the presence of needles, syringes and cobalt at his yard. And the IHRB referral committee Interestingly, didn't find that he was in breach of the rules for possession of illegal substances, but did say that his conduct was of a serious nature. He was found not to have maintained a medicines register for some time prior to inspection, or to have ensured he and his staff with access to medicines were fully conversant with the rules and regulations relating to prohibited substances, and, this is my favourite bit, had failed to be responsible for the safekeeping and administration of medicines, having failed to securely lock the medicines cabinet. How careless. Which brings me to, happily, the final slide, and I'm going to hand over to Jonathan.
Sam, thank you very much indeed. Some of you may have questions for Ben and Sam. Can I ask, perhaps if it's all right with them, if you take those questions when we break after Anne-Marie's talk to have a cup of tea or coffee, so that we can move straight on to hear from Anne-Marie. But before we do, we'd like to show our appreciation to Ben and Sam for a really interesting talk. Thank you.